Well, hello everyone out there in Zoom land. So thank you for attending this evening. Tonight we're going to talk about the recent changes in the Fair Housing Act and the Fair Housing laws. Uh, the Fair Housing Act has been changing for about the past decade as more and more condominium associations are created throughout the country, and the liberalization of animal companions in the aid of mental health and other disability related causes has grown. The Fair Housing Act has been adapted over the years to follow the trends that we're seeing as a society. And in 2020, the United States Department of Housing and Urban Development came out with a document which hopefully all of you have received in the materials that gives more detailed information regarding animals and how animals will now be treated under the Fair Housing Act. Because we've all heard the stories, right? You show up at the airport and someone has a care peacock on their shoulder, which I've always thought, I grew up in South Phoenix, and in South Phoenix, we had a lot of farms. At that time, when I was growing up, there were a lot of farms in South Phoenix. Now it's all houses. And a lot of those farms had peacocks on them. So I grew up around peacocks, right? And they're pretty big. And when they spread out, they really spread out. So to get and I was always afraid of them, by the way. But to get a peacock on your shoulders is a good one. And then we have the example of the care llama, the care monkey, the care, and of course, there is a difference between a lemur and a monkey. They're primates, but they're different. And so all of these examples that we see in the news and in the press, and the reaction to what we've seen from airlines, from hotels, from housing providers, apartment complexes, stores, things of that nature, it was really required that the government, that the Housing and Urban Development really provide us with guidance regarding what types of animals are going to be sufficient under the Fair Housing Act. And we have to understand and highlight the fact that we're talking about the Fair Housing Act. We are not talking about the Americans with Disabilities Act. Those are two distinct and separate acts. And the guidance that came out in 2020 regarding animals draws a clear distinction, a very clear distinction between how animals will be treated under the Fair Housing Act and how animals will be treated under the Americans with Disabilities Act. So during this presentation, you may have a question and you may hear me say, well, that may be true under the Americans with Disabilities Act, but it is not true under the Fair Housing Act. So what is the fundamental difference between the Fair Housing Act and the Americans with Disabilities Act? The Americans with Disabilities Act deals with public accommodations, right? Areas in which the public have the ability to enter onto and to exist in. So grocery stores, this space that we're all here today, auto dealerships, malls, hospitals, government buildings, law offices. Those are all spaces of public accommodation. And so those public accommodation spaces are subject to the Americans with Disabilities Act. Hotels, right? Americans with Disabilities Act. Now, the Fair Housing Act covers housing and housing related infrastructure. Okay, so it specifically has to be a housing related phenomenon. So apartments are not Americans with Disabilities, they're Fair Housing Act. Unless, I like to say, I was writing an opinion letter today, every legal question has that except that goes at the end of it, but apartment complexes, condominiums, planned communities, homeowner associations, mobile home parks. Those are areas that are subject to the Fair Housing Act. And the Fair Housing Act is it's probably one of the most comprehensive acts that we as a people have. Fair housing goes all the way from animals to housing for older persons. So the Fair Housing Act on one end says you cannot discriminate based on age, but then on the other end of the Fair Housing Act, it says, well, yes, you can discriminate on the basis of age when it's housing for older persons. So the Fair Housing Act is a very large act, and we're just going to talk today about a very small section of that act. And the small section that we're going to talk about today is how the Fair Housing Act relates to disabilities and those individuals who reside in housing and they are disabled. Okay, again, that's a wide, that in and of itself is a wide fairway for all you golf fans. You can't miss that fairway, but we're gonna narrow it even more, and we're gonna talk about a few key issues. We're gonna talk about animals, and we're gonna talk about marijuana. Marijuana is a growing niche in the fair housing law because now, Arizona being one of them, recreational marijuana is now legal here in Arizona as it is in several other states. In more states, medical marijuana is legal. And if you've been following the news lately, President Biden is going to commute and pardon all the sentences of anyone who's been convicted of simple marijuana possession. So marijuana is starting to turn into cigarette smoke, which under the Fair Housing Act is a problem. So cigarette smoke under the Fair Housing Act would be a problem, but marijuana isn't. The joys of the Fair Housing Act. Now, I'm gonna make a statement about the Fair Housing Act before I go deep into it. And it's my own editorial. I'm not a politician, thank goodness. As a lawyer, I can interpret the laws as I intellectually deem fit. And so I love to make this statement about the Fair Housing law, of the Fair Housing Act. The Fair Housing Act intrinsically is not fair. The Fair Housing Act intrinsically is not fair. It is misnamed. It is misnamed. It maybe should have been called the Equal Access to Housing Act or something to that effect. But to call it fair is not necessarily the case. And why would I say that? Because as a healthy individual, why can't I keep my 50-pound pit bull in my 800-square-foot apartment? If the association says, you cannot keep a pit bull in your apartment, okay, well, I buy a condo in the association. CC&R say that I cannot have a 800-pound pit bull in my apartment, so I wanna have one. But my neighbor has an 800-pound pit bull in his apartment. Why? Well, he falls under the Fair Housing Act. Well, how is that fair? The original authors of the Fair Housing Act would say that, people who are disabled have equal access to the use and enjoyment of their property, which is something that I 100% agree with. Disabled people should have equal access to the use and enjoyment of their property, but there's a line there. And we're gonna explore what that line is tonight. So what entities are covered under the Fair Housing Act? I briefly touched on that topic. The Fair Housing Act protects all protected classes of race, creed, national origin, familial status, sex, which again, sex now, actually no, there's one missing. There's also sexual orientation on the federal level. So that could be, I guess you could put that under sex, but sexual orientation is also now protected federally, and I believe in the state as well, under the Fair Housing Act, familial status and disability. So if you are an individual that would fit into one of those categories, the Fair Housing Act is there for you to avail yourself of. Who must comply with the Fair Housing Act? As we discussed, those who provide housing. Now, housing in the sense of permanent housing, not vacation-related housing like a hotel. A hotel would be under the Americans with Disabilities Act. But if you're providing residential housing in any way, shape, or form, you are subject to the Fair Housing Act. Now, this here is for, I always get a lot of what I like to call policy wonks. And in the surveys, they say, you never quote enough statutes. And that, as an attorney, we got to keep some, I'm like a magician. I can't show you all my tricks, right? But for all of the policy hacks out there, I listed out the specific statutes and the specific wording of the statute in regard to what is a violation under the Fair Housing Act. And to just say it colloquially, you cannot discriminate against a member of a protected class in the providing of housing. Okay, and the key term there is someone who resides, a resident. Okay, because a resident can take several different forms. A resident could be someone who lives there all the time. A resident could be a visitor. Okay, so a violation of the Fair Housing Act is when a housing provider discriminates against one of those protected class members by failing to provide them access and equal use and enjoyment as a resident to the housing that they're seeking to reside in. That's a renter, that's a buyer, that's a visitor. That's your Aunt Sally from Minnetonka who's coming in for 4 weeks to say hi. Anyone that's residing in that unit is considered subject to the Fair Housing Act. Now, something else that I get a lot of questions on is, so when the act says you are providing housing, what does that mean? Well, that's exactly what it means. You are providing shelter. So if you own a property and you're providing shelter to a friend, you're a housing provider. If you own shelter and you're renting it out, you're a housing provider. And again, as I said, anyone that's taking advantage of that shelter, a resident, is someone who's protected under the Fair Housing Act. Now, the violation occurs when the housing provider refuses to provide the protected individual with a reasonable accommodation to any set rules, procedures, or guidelines required to occupy or reside in the housing. Okay, so we all have housing rules. Even with me and my kids, there's certain things that I'll let them bring in the house, and there's certain things I won't let them bring in the house. But on a more general level, in community associations, the CC&Rs or restrictive covenants contain rules and regulations regarding how you can use your property. And we see a lot of that in condominium associations where we have pet restrictions. We see some of that also in planned communities as well in regard to animals, and we will talk about that. But in essence, a housing provider who fails to provide a reasonable accommodation that will aid a disabled individual in the use and enjoyment of their residency in a housing scenario is a violation of the Fair Housing Act. So out of all of the protected classes under the Fair Housing Act that the Fair Housing Act protects, the one area that really is at the forefront is the area of disability. Gone are the days of the racial and religious restrictive covenants. I think those have uniformly been stricken from the restrictive covenants throughout the country. So now when we deal with the Fair Housing Act and we deal with a protected class, we're really looking at the disabled and ensuring that the disabled have equal use and enjoyment of their property. Okay. And so obviously, if we're going to focus on a particular class in the fair housing genre there, we have to define what we're talking about. In the law, defined terms are very important, and we must understand the defined term in order to continue to understand our responsibilities under the law. And so, okay. So again, for you policy wonks out there, I give you the specific US code, you like that, and the specific Arizona revised statute provision. So have fun on Google looking those up. But though in those aspects of the statutes, it defines what disabled is. And we're going to use the term disabled for our conversation tonight. I don't know if, sometimes I can't keep up with the political correct terms these days, but I know the statute says handicapped or disabled. I know handicapped is sometimes not favored as a term. So we'll just use disabled because that's in the statute. So what is a disabled person? A disabled person is a person with a physical or mental impairment which substantially limits one or more of such person's major life activity. Okay, now that's a very loose and broad definition. Very loose and broad definition. Many a community association has made a mistake in trying to curtail or limit that definition. Any physical, or more importantly, mental impairment that affects substantially one or more of a person's major life activities is a disability. Okay. Now, obviously, there are certain disabilities that you know when you see, and there are certain disabilities that you would not know. Some aspects of the mental disabilities, but there are also some chronic conditions that individuals may have that would be considered a disability that would bring them into the protections of the Fair Housing Act. Now, we're going to discuss how we make this determination on disability or not. But it's important to understand that disability is a very broad term. And narrowing the definition of disability is done at your own peril. Now, of course, you can prove disability by having a displayed record of having an impairment. So if someone has a disabled veteran's plate on their car, they are disabled. If someone is receiving disability checks, they are disabled. So, if you have a record of a disability, then you'll be considered disabled, or, excuse me, being regarded as having a disability. This is more of an amorphous definition, but if you know that the person is disabled, then they're disabled. Now, the last term here, but such term does not include illegal use of or addiction to a controlled substance. That's rapidly changing. Rapidly changing. The exemption used to be illegal drugs. Is the use and addiction to illegal drugs is not a disability. It's a choice, some would say. Now medical science is leaning towards it not being a choice, and medical science is leaning towards it being a disability. Moreover, some what we would consider, well, they're not considered illegal anymore, are there? Drugs such as marijuana, which would have been on this list 8 years ago, is no longer on the list. It's no longer, in fact, using marijuana could be proof that you are indeed disabled. And so, again, illicit or illegal drugs, being addicted to or using illicit or illegal drugs is changing daily as to whether that could be a disability or whether that would be a carve out from being a disability. Sure, yes.
I agree 100% that the home
Yeah, 1 second. Are you getting a mic? I am. Okay, good.
But right now, marijuana is classified still as a controlled substance by the federal government, correct?
Not after President Biden pardoned everyone for simple marijuana possession.
No. He pardoned them for possession, but he didn't recommend that the classification of marijuana be changed.
But it's not enforceable. It's not enforceable here in Arizona.
But that's for possession. But dealing and selling and stuff like that, that still is illegal, correct?
Well, dealing and selling would be synonymous, but yes, it depends on how much you have on. It's not a question of dealing or selling. It's a question of how much you have on you at the time.
All right. But in terms of the controlling, like the class 1, 2, 3, 4, and 5 drugs, that hasn't changed to my knowledge.
No, what's changed is it a medical, is being addicted to a class 1 drug a medical condition? That's
Okay.
what's changed.
Right.
So if addiction is a medical condition, then it's the state of being addicted is a disability,
Okay.
which would fall under the Fair Housing Act.
Right. But the actual classification of marijuana today is in the same class of drugs, class 2, as it has been in the last 10 years that I'm aware of.
Sure, it's just
Right.
it's a distinction without a
Okay.
without a point because it's not enforceable. But yeah,
Okay.
you are correct. Oh, I must have accidentally pressed the button. Okay. So again, how do we establish when someone is disabled? Open and obvious if they're in a wheelchair or walker, they're disabled. Receiving disability or Social Security benefits, or written documentation. Notice I say from a medical professional. You see the word doctor there? You don't see the word doctor, do you? All you see is the word medical professional. So that's all that is needed. A letter from a medical professional stating that someone is disabled means that they are disabled. It also means that you as an individual layperson do not have the right to question the qualifications of the medical professional.
Augustus, I had one quick question
Sure.
from someone online. Where would alcoholism stand as a disability?
So alcoholism actually is a disability. Alcoholism is a disability. And so that would bring someone into the category of of being disabled. Yes.
So going back to the beginning there, I know there's some kind of a gray area between a hotel and a home. Where would an Airbnb or a short-term rental fall on the disabilities? Would that be covered under the fair housing or would that be ADA?
So to answer your question directly, short-term rentals is a residential use. That's been decided in case law nationwide. So that would be Fair Housing Act. Yeah. Why that is a very complicated legal analysis as basically, and I'll make it very simple. If the structure was built with the intention to be used as a single family residence, then it is a single family residence and it's fair housing. So they build a beautiful master plan community in Scottsdale. They built it to be residential homes and then it turns into Airbnb. The intent was for it to be residential. Therefore, it is residential. It's FHA. So yes, medical professionals. Again, I've had a lot of associations over my 22 years say to me, "Well, that person is not a doctor." Well, you don't have to be a doctor. Well, that person is giving a diagnosis on a mental illness, and they're a chiropractor. Well, you do not have the ability to challenge the medical provider's qualifications. It's the decision of that medical provider that this disability is a disability, and you have to live with that under the Fair Housing Act. Uh-oh. So now we get into, again, we're talking about disability, and we're talking about how the housing provider or the homeowner association or whomever we're talking about can determine whether someone is disabled. And the list I gave before, if you know that they're disabled, they're disabled. If they're receiving benefits from the state or from the government, they're disabled. If they have a letter from a doctor, or excuse me, see, I even made that mistake. If they have a letter from a medical professional stating that they suffer from a disability, then they are disabled. Okay. And as I also said, sometimes you have disabilities that are not readily apparent, right? And those are disabilities of the mind. Sometimes, we all could be suffering from some mental instabilities and we could be disabled, right? But we would not outwardly show that disability. And so it's important to understand that on issues where someone doesn't outwardly show a disability, you could ask for information regarding that disability because it's not apparent. You can't see the disability. You're able to ask. But in situations where the disability is apparent, you cannot make that person verify the apparent disability. So if I come in here walking with a cane, I am disabled. That's the end of the discussion. So as I was saying, if the disability is not open and obvious, there are some things you can request. You can request a letter from a doctor or a medical professional. Actually, the reason why this says doctor is you make the request for a doctor. You're not required to make the request simply from a medical professional. You can make the request for a doctor. Now, if you get a documentation from a medical professional, you have to accept it. But you don't, you could just say, hey, I'd like a letter from your doctor saying that you're disabled. And the letter from the doctor must state the disability and how the requested accommodation will affect the disability. Yes.
The medical professional must be licensed in the state that they're practicing, correct?
I didn't say that.
Well, no,
I said medical professional.
okay, but so even an unlicensed medical professional can give somebody a letter and everybody has to accept it?
I said medical professional. I didn't say anything about licensing, did I?
Correct. That's another reason why it may not be fair to call it the Fair Housing Act.
Yeah, I didn't say license. Lawyers, we're very careful with our words, aren't we, us lawyers? And so are people who draft statutes. I noticed that I never said licensed medical professional. I just said medical professional. And a lot of associations will get caught up in that. They'll get a letter from someone in Maine, and they'll say, well, we don't live in Maine, we live in Arizona. This person's not licensed here. It's not adequate. No, the FHA doesn't say anything about license. It just says medical professional. Yeah. And you're going, you're going to hear me say a lot of things, and you're going to say to yourself, well, that can't be. 22 years of dealing with the U.S. Housing of Urban Development and the Arizona Attorney General's office under various administrations, from conservative to liberal to right in the middle. 22 years is a long time dealing with the FHA. They rarely deviate. Don't mess with the FHA. You will lose every time. I will give you the example of the 3 times that I have won out of about a couple hundred, 3 times that I have actually won an FHA case, okay? The first time is when a disabled, I can't believe, as a veteran, this one hurt me that I won. A disabled American veteran had a large dog in a condominium, okay? Proof that he was disabled. The accommodation was reasonable. but there is a exception to the, and we'll talk about that. There's an exception to the animal rules that says that if the animal is inherently dangerous, or if it's a dog under the one bite rule, the dog has attacked, then they're exempt from the FHA. So this is a situation where the dog attacked another dog in an elevator. I was able to prove that the dog was inherently dangerous, no FHA, the dog had to be removed. And then the other times that I won were basically based on one of the animals was a monitor lizard, which is still a wild animal. And wild animals are not subject to the FHA, which we'll talk about later. And then two wild animals, monitor lizard, and it was a pig, but it wasn't one of the domesticated, well, all pigs are domesticated, but it was not one of the pot-belly pigs that are commonly used as pets. It was an exotic breed of pig, which I was able to fit under wild animal, even though all pigs are domesticated. I'm still kind of iffy on why I won that one. Otherwise, I lose. And what do I lose on? Questions like what type of medical professional was it? Was the medical professional licensed? That guy's not disabled. He has diabetes. He's not disabled. He walks and talks and plays golf and does everything that I do. How does that guy get to park in the specialist parking? He's not disabled. Well, under the law, he's disabled. That guy is an alcoholic. How is he disabled? Alcoholism is a disability now. So, and we'll talk about some of these examples a little later on in the show. So now we know what a disability is. So the way the Fair Housing FHA scenarios usually occur is an individual is breaking an HOA rule. This is how it works. An individual is breaking an HOA rule and the HOA is seeking to enforce the rule. And in response to enforcing the rule, the individual says and requests a reasonable accommodation, meaning a variance to the rule because they are disabled under the Fair Housing Act. Okay, now what's important to understand is that the variance to the rule must relate to their disability. So first they must be disabled, and we talked about how we determine whether they are disabled. Next, the rule must relate to their disability. Okay? And if the variance to the rule relates to the disability, that is called a reasonable accommodation. And that reasonable accommodation must be provided. Okay? So I'm going to give you 3 scenarios on how these situations usually play out. I gave you the first scenario. An owner is in violation of the rules. The association enforces the rules. The owner comes back and says, I am disabled. I need a variance in order to allow me to use the property pursuant to my disability. In that situation, the homeowners association will evaluate the disability. If the person looks disabled, stops there. If you know the person is disabled, you know that you see them driving around the neighborhood with the disabled license plate, it stops there. If the owner presents to you disability paperwork from the government, it stops there. But if none of that's present, then you can ask the individual for a doctor's note. And so the individual will provide you with a note from a medical professional. Notice I said medical professional again, not licensed doctor, not licensed anything. I said medical professional. And then we've established that there's a disability. Next thing that we need to establish, however, is will the requested variance aid them in regards to their disability? And that's where we get to animals. and marijuana, which is the topics that I want to really focus on here today. Now, as I said earlier, the only time that I won a fair housing issue is the requested variance creates an administrative financial burden or a danger. Okay, an administrative financial burden or a danger. So when it comes to animals, inherently dangerous animals we're going to be talking about that because that's been redefined in the 2020 guidance from HUD. And they've actually included some wild animals as animals that would now be accepted. Used to be, if the animal is not domesticated, it doesn't comply with the Fair Housing Act. And, you know, domesticated animals or farm animals, dogs, cats, you know, lizards used to not be domesticated, but now they fit under the new guideline exemption, snakes, things of that nature. Okay, or animals that have attacked before, they're automatically inherently dangerous and they're not protected by the Fair Housing Act. Now, an accommodation can also be administratively too expensive. So if it would cost an HOA a great sum of money to provide the reasonable accommodation, then the reasonable accommodation can be denied. I've never seen that happen. Because, you know, HOAs are made of money, they say. Okay. Sure.
This is probably going to sound strange, but as a person gets older and you're living in an association that's for a long time, and this is a financial situation where they start digitizing everything, and then you need apps, and we have laundries, and all this is becoming, if you want to use the facilities on the property, you have to get this app and you have to use it in order to use and for someone who is not as myself, who is at an age where I don't want that expense. I feel that that is a disability to me, that I've been living on the property for a long time. And they have decided to do this, a number of things. It's not just digitizing everything. That if I want to use the pool, the laundry, or the clubhouse or anything, they have this app. Now, my question to you is, what are these apps? How much information do they have on all this new stuff that is coming up, and they're doing this property, and I don't want that expense, and I don't want to do that.
So if you would have come to me as a lawyer, I would have said, be quiet. Because when you said, I don't want, you destroyed your case.
Oh, okay.
It's not about what you want.
Well,
It's about whether
what I
you
can
are
afford.
No, it's not about what you can afford either. That's why if you came to me, I would have said, don't say about what you want and don't say what you
Okay,
can
well,
afford.
That's what I'm here to ask.
Say, I have a disability
Okay, that's
and
what
I
want.
cannot, and my disability does not allow me to operate these gadgets.
Okay,
And go find yourself a medical professional that'll say that, and then they'll have to accommodate you.
okay.
But when you base anything on what I want or what I can afford, you
Okay.
automatically lose.
That's exactly what I wanted to hear.
Yeah. Now, I didn't mean to get on you, but I just gave you a whole bunch of really good free advice. So, let's expand on that question because it's a great question. I've run into that. I represent several large retirement communities that I'll never be able to live in. I'm getting close to being able to live in them, but I have a 5-year-old son. And so they have that tricky no kids allowed in retirement communities. So I don't think I'll ever be able to live in an retirement community with a 5-year-old son as the ages go. But I love them. I wish I could. You know, in a few years, when I'm old enough, I 2 years, 1 year, when I'm old enough, I'd be there in a second. However, they are modernizing very, very quickly. And some of them in their modernization are still prepping and allowing for more traditional methods to be used. Some aren't. And there is no right to stop them from modernizing unless you have a disability. And the disability could be broad. You know, I wear glasses, and these are like trifocals or something like that. You could say that, you know, you cannot see the phone in order to load the app, in order to use it properly. I'm disabled. Or, you know, my hand, well, you could say whatever you want, as long as you can get a medical professional, as long as you can get a medical professional to agree or to diagnose you with that disability. And then you take that letter to your HOA and you request that your HOA allow you to continue to access the spaces the way you were accessing them, and you'll be fine. The good thing about not being a doctor is I don't diagnose disability. I can tell you what what a disability would be under the law, but I don't know. So hopefully that answers your question. Was there a question from the online people? No? Okay. Okay. Now, I think we've been talking about how to avoid fair housing lawsuits. You just don't get into them. Really, just don't get into them. Work with people with disabilities and try to accommodate them the best way you can. I am one of those attorneys that says, better that you give an accommodation than you deal with the Arizona with the Arizona Attorney General's office. Because the only person that wins when you go to the Arizona Attorney General's office is me, because I get paid regardless. So, you know, we want to avoid these things. And how do we avoid them? We have what I call a reasonable accommodation modification policy. Every association should have one because it makes the decisions regarding granting a reasonable accommodation very easy. You can give that policy to all of the owners. The owners can understand it. The owners can abide by it. And it makes these types of decisions automatic. Now, some associations have said, well, Augustus, if you disseminate a policy, then people will try and take advantage of the policy. And that's, you know, because people will find a medical professional that will say whatever they want them to say, and boom, you're in a fair housing scenario. And my response is what I told you earlier. Fair housing isn't fair. Better that you have a good fair housing policy, and some people take advantage, then you spend tens of thousands of dollars to have the Arizona Attorney General order you to do it anyway. No, the pet slide is, yeah, I did miss it. I missed all those slides. Okay, let's talk about pets. I thought that the pet slide was after, but I guess it's right here. So let's talk about pets. So again, as I said earlier, the Americans with Disabilities Act and the Fair Housing Act aren't the same. Okay, there are different requirements when it comes to animals. When it comes to training of animals, what types of animals will be allowed, things of that nature. Okay, so the ADA, the FHA is far more lenient than the ADA, than the Americans with Disabilities Act. The FHA, their definition is emotional care animal or support animal. Okay, now, these animals do not have to be trained. That's another issue that we get ourselves into in these fair housing situations. We'll see a very badly behaved dog, and the board will say, well, that dog's not trained as a service animal. Get him out of here. Well, under the Fair Housing Act, the animal does not have to be trained. Very, very important. And now the animal can be trained because service animals are now also allowed. So if you want to have a service, I have a poodle, and poodles make the best service animals because they're smart and they're dedicated and they love you. But under the FHA, it doesn't have to be a trained animal. It could just be an animal. Did you have a question?
It's just when you have that sentence, training of said animals, why do you have may not be required? Why don't you say are not required?
Because I'm a lawyer. We always equivocate.
Okay.
Just like if I would have had that slide from 6 years ago, I would have said marijuana was a controlled substance. It's going to depend on the animal. Again, let's say you have a dog that is bitten before. Now, the once bite rule would say that that animal is an inherently dangerous animal. He's disqualified. However, if that animal can be trained and that animal has a certificate of training after that animal has bitten someone, that may push that animal back into being accepted. So that's why we equivocate as lawyers. There's always an example. Now, any animal that is not inherently dangerous may be considered. Remember the slide where I showed you the wild animal? Well, now we have a different scenario here. So if you have a very well-behaved lemur, and the lemur, is not known to be a dangerous animal, now that lemur can be your emotional support animal. I had a situation in northern Arizona where we were talking about geeses and swans. The swans are wild animals. And if you guys have ever, most of our experiences with swans is that we see them on the water. They're so majestic. They swim along and we say, what a majestic animal. You get close to a swan and they are meaner than a goose. Swans are no joke, especially when you keep them in the backyard, northern Arizona, without any water. They're not friendly animals, but they are emotional support animals under the FHA, according to the Arizona Attorney General's office. I'll never let my child near a swan. They're nasty. Beautiful, but nasty animals. But they're not inherently dangerous. Some would say. That's my equivocation, some would say. Also, in the past, a number of cities have come out with inherently dangerous dog breeds, where they'll have a list of dog breeds that are just inherently dangerous. Now, after much litigation, there is no such thing as an inherently dangerous dog breed. So, as I said, I guess so. Well, there was a misconception that a Rottweiler was an inherently dangerous dog breed, but they're not. You have to train the Rottweiler to be an inherently dangerous dog breed. So the American Terriers, the American Pit Bull Terriers, they can be considered inherently dangerous because they were bred for fighting, right? But there is no inherently dangerous dog breed under the FHA any longer. So a pit bull can be a care animal. So if you're in a condominium, in a 500 square foot condominium on the 52nd floor, and you have a pit bull, as long as that pit bull hasn't bitten anyone, that pit bull can be an emotional support animal. And again, when it comes to these animals, it's important that in the situations where you are allowed to ask, because remember, if the disability is readily apparent, you're not allowed to ask. But in situations where you are allowed to ask about the disability, ask how the specific animal is going to aid in that disability. Now, unfortunately, there isn't much wiggle room there. Most medical professionals will find a legitimate way to say how that animal will help with the disability. And once you get that in writing on a piece of paper, you are stuck. You're stuck. Let's talk about marijuana. Now, as we discussed earlier, marijuana in this state, at least, is now, well, here in California, I believe, I don't know about Nevada, but recreational use is now permitted. It used to be a scenario where we were a medical use only state. And so fair housing issues were easier with marijuana because marijuana could only be used pursuant to a prescription. Okay, now that's not the case. So now we get a lot of issues with marijuana being used in common areas and marijuana being used in condominiums. It's funny how marijuana has become more friendly than tobacco when it comes to smoking. It's hilarious, right? Because smoking tobacco, what doctor, now let's think about this for a second. What doctor would give you a prescription to say, smoke some tobacco? The nicotine will help you. Here's a prescription, smoke tobacco. But you can find a doctor that'll give you a prescription that says, here, smoke marijuana. I'm not editorializing, I'm just, sometimes I want to be a stand-up comedian, and I think that's just observational humor. So an association could ban smoking on the common area, right? So if you have a park, you can say no smoking of cigarettes in the park. You may not be able to say that regarding marijuana, because marijuana can still be prescribed as a medicine. And if the person is disabled, the person can request a reasonable accommodation to smoke marijuana in the park to aid them with their anxiety in the park, to aid with their disability. So now you cannot smoke cigarettes in the park, but you can smoke marijuana in the park. Fair Housing Act is not fair. And I get a lot of that. And the reason why I highlight it is because I've gotten a lot of that. Families with kids, this guy's smoking marijuana right next to my kid. I mean, he's secondhand smoke, blah, 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 blah. We need to stop this. Association creates a rule, no smoking in the park. Person comes to the association, here's my doctor's note. I need to smoke marijuana in the park. We go to the AG, we fight it. The AG says, what are you doing? He's disabled. Here's a doctor's note saying that he needs the marijuana. It's a reasonable accommodation. Let him smoke it. Pay him $10,000. Oh, and create a policy about reasonable accommodations and modifications. And then the board looks at me and says, do we still have to pay you? Yeah, you still have to pay me. So yeah, let's understand. Now, that doesn't mean that if you see someone smoking marijuana in a public space in an HOA, you just say, oh, they must be disabled, because again, we do have recreational use now here in Arizona. So what I usually suggest is, if you are so inclined, have a general no smoking rule in your parks, or in your common areas. Most associations have no smoking rules in their common areas. We can't smoke in here, could we? Could I smoke marijuana if I had a doctor's note? I used to know the attorney for the city of Scottsdale. I think she's moved on. Yes.
When does something that affects your mind and you're not able to make clear what is happening? Can it be like if you live in like a condominium and you have people with marijuana, they even smoke in their home, but you have a tier,
Mhm.
which is good. If they smoke too much, maybe in their mind doesn't make good decisions and you cause a fire or something. When does something that affects your mind create?
You know what's funny about that? If you use the same example with alcohol,
Right,
that person would be negligent
right,
and they would be responsible for their action.
right.
Now, if they're using marijuana under a doctor's prescription and they're using pursuant to the doctor's prescription, so they're not using more than what the doctor prescribed, they're doing exactly what the doctor tells them, they most likely would not be negligent under the law because they're following a doctor's order. Now, that's medical marijuana. Recreational marijuana is treated just like alcohol.
Okay,
If you're smoking a bunch of recreational marijuana and you do something stupid, you are responsible for that,
right.
right? But if you're under a doctor's care in your home, now if you're driving, it's the same thing as, there is no medical exemption for using marijuana while you're driving. But if you're in your home and you have a doctor's note and you're using it pursuant to your doctor's note, you may have a defense there.
But there's more people smoking marijuana that are not medical
Yes.
and they're living in
Yeah.
properties that have,
Yeah, exactly. Which again, it's just another challenge we all have to face. And it just really requires condominiums to really rethink their no smoking policies and things of that nature.
they can do that.
Yeah. Yeah. They can have no smoking rules in the common area, on the common elements, absolutely. No smoking in elevators, no smoking in hallways, no smoking in common rooms. Yes, they can absolutely do that.
I'm talking, I live in a three-tier. I'm talking about the person above me.
Oh, in your specific unit, can they say no smoking?
Yeah, there's.
Well, it
people
depends
above me, people below me, marijuana's all over the place now.
There's a lot of factors there because I don't know if that's recreational marijuana or if that's medical marijuana. I don't know.
Sure, it's recreational.
Never assume.
I know, I'm just talking about the people that I know.
Yeah, yes. So what I recommend is, really start to look at those no smoking policies and then treat exceptions under the Fair Housing Act if you have a medical marijuana situation that presents itself. Now, vape, because no one smokes anymore. It's amazing. The older I get, how things change. We go from, when I was hip and cool, I had a beeper, and now I have one of these. We go from cigarettes to, I don't know, I call them robot things because I see them now. They used to look like cigarettes. Now they look like thumb drives. Now they look like all types of traps. I don't know. So, but is vaping smoking? And is vaping marijuana smoking marijuana? Right? These are tough questions. Vaping is likely not considered smoking. Well, but it may not be considered smoking. And vaping marijuana, well, you're vaping the oil, which is illegal, I think, depending on the strength of the oil. But anyway, associations that are concerned about vaping can understand that vaping is likely not going to be considered a disability. So that would not come into play under a Fair Housing Act scenario. Vaping is like smoking, which is weird. Addiction to smoke is not a disability, but addiction to alcohol likely is. It's a fun world under the Fair Housing Act. Thanks, everyone. Have a wonderful evening. Thank you.
Thank you.